Superior Court Judge, co-sponsored by the Sonoma County Bar Association and the League of Women Voters of Sonoma County. I'm Edie Mendez, a member of the League, and I will be your moderator this evening. The mission of the League is to encourage informed and active participation in government and to influence public policy through education and advocacy. The League does not support or oppose any political party or any candidate. We're currently celebrating our 90th year, and even though we are the League, of Women Voters, we are delighted to invite men to join us as well. Tonight's forum presents the candidates running for Superior Court Judge in 2 seats. Before I introduce them, I would like to outline the format for the forum. Candidates are seated as their lots were drawn, and they will be making opening statements in that order of 2 minutes each, beginning with the 3 candidates on my right who are running for Office 2. I will then, after the 3 of them are completed, turn to the 2 candidates for Office 3. Each candidate will make the 2-minute opening statement, and then when it comes to questions, I'll be rotating the order of the questions between the 2 races and between the candidates within each race. Each candidate will be allowed 1.5 minutes to respond to each question. We will begin with several questions developed by the moderator with assistance from the president of the Sonoma County Bar Association, and then take written questions from members of the audience. If appropriate, I may allow a round of rebuttal responses at 30 seconds each. At the end of time for questions, each candidate may make a closing statement of 2 minutes, and these closing statements will be in changed order from the opening statements. We have 2 timekeepers this evening, Amy Southwick and Andrea English. They are seated right here in front. Please show us the 30-second card you're going to be showing. That obviously lets you know you have 30 seconds left to speak. And then a red stop sign. So that means please finish your immediate thought and stop. Time limits are closely followed to ensure fairness to all candidates. We ask the audience to please withhold your applause until the end of the forum, and please turn off your cell phones and such now, as well as their screens. Thank you very much. This is not a debate, but a forum about issues facing the judicial system in Sonoma County. On my right are the 3 candidates for Superior Court Judge Office 2, seated in order of their lots drawn. Mr. Lamont, Mr. Casey, and Mr. Broderick. A separate race on my left, the candidates for Office 3, Mr. Mazzia and Ms. Thistlethwaite. You will be able to vote for 1 candidate for each of these offices. All of the offices are 6-year terms, and also for Office 1. The candidate for Superior Court Judge Office 1, Nancy Case Schaefer, is here this evening, and she would like very much to meet you afterwards in the lobby for discussion, where the other candidates will be available as well. We will now hear each candidate's 2-minute opening statement, and we will begin with Mr. Lamont.
Thank you, Edie. Thank you to the League of Women Voters, and thank you to the Sonoma County Bar Association for hosting this important forum to help provide for an informed electorate. A Superior Court judge should have civil, criminal, and administrative experience and training, and fortunately, I meet that test. I have represented both civil plaintiffs and defendants in various forums. I have criminal experience as a prosecutor and as a criminal defense attorney. And I have administrative law experience in both state and federal courts. I have tried jury trials to successful verdicts in both the civil and criminal courts. But there's a bonus. I also have the most judicial experience of any candidate before you. For 17 years, I have served as a judge pro tem, now called a temporary judge, and another 15 years as a Superior Court Settlement Conference panelist, volunteering here in Sonoma County to our community. I hold both a doctorate in law and a master's in business administration, and I want to bring my background, training, and experience to you as your next Superior Court judge. I believe firmly in our community, and I want to keep it safe. My maternal grandfather played football at Annalee High School in the 1920s, and my great-grandparents had a ranch on the Moon Mountain in Sonoma Valley before that. I have volunteered in the community as Commissioner of the Sonoma Valley Citizens Advisory Commission, taught mock trial as an attorney coach at Sonoma High School, guiding the students to a county victory and placing very high in statewide competition. I judge the Lions Club speaking contests, and I'm active in emergency rescue with the National Ski Patrol. I serve on the board of directors of the Bar Association and volunteer as a fee arbitrator for them. Our community includes my wife and my 5-year-old twin boys. They are part of the most vulnerable segment of our society, which brings me to the bottom line. The number one priority of government is public safety, and that's what I bring to you.
Thank you. And next, Mr. Casey.
Thank you. Good evening. It's a great pleasure to address this group, and I deeply appreciate the opportunity. My name is James Patrick Casey. I'm a senior deputy district attorney with the Sonoma County District Attorney's Office. I've been a lawyer for 30 years and a career prosecutor for 25 of those years. I've tried well in excess of 100 felony jury trials to a verdict, including murder, rape, robbery, child molestation, narcotics, really the gamut of the human condition. I'm currently the senior trial prosecutor in my felony jury trial department. I joined the DA's office in 1990 after having served for 5 years as a deputy district attorney in Oakland during the crack cocaine war of the mid to late 1980s. Prior to that, I was in the private practice of law with an emphasis on business litigation. In addition to my deeply rooted professional skills, I bring some unique life skills to the Superior Court bench. I am a retired United States Army infantry officer and a Vietnam combat veteran. I was commissioned as a second lieutenant when I was 19 and a half years of age and had the great privilege of commanding a rifle platoon in Vietnam from early autumn of 1967 through the late spring of 1968 when I was very badly wounded. Terrible time in a terrible war. We were losing 400, 500, and 600 Americans killed a week in that time frame. I spent 18 months at Walter Reed Army Hospital in Washington, D.C., undergoing 8 major surgeries and learning how to walk all over again. I was then retired at the ripe old age of 23 because of my wounds, and the good Lord gave me a second wind, and I then went to college and law school on the GI Bill. I've been married to a miracle called June for 38 years, and we have been blessed with 4 wonderful children. And to prove the old adage that the acorn doesn't fall far from the tree, my daughter is a deputy district attorney here in Northern California. I am a very common sense, pragmatic person. I am a proven decision maker. I have made decisions in both wartime and peacetime involving life and death. I know the dignity of life and the respect we should have for life. Thank you.
Thank you. And next, Mr. Broderick.
Good evening. I have the extensive and broad experience to make an immediate contribution to the Sonoma County Superior Court. I believe that a judge must protect the public by being willing to hold people accountable for their actions. A judge must also have the vision to work hard to make sure that all people have access to justice. For over 15 years, I have served on hundreds of occasions as a Sonoma County Superior Court Judge Pro Tem, presiding over thousands of cases in criminal, civil, and juvenile courts. I have presided over more than 5,000 criminal misdemeanor matters, including presiding over criminal jury trials from jury selection to verdict. I have heard hundreds of juvenile court matters, including presiding over juvenile court trials. I have also presided over civil departments in a variety of matters, including presiding over civil court trials and civil jury trials. I have served as an arbitrator and a mediator for the Sonoma County Superior Court. I have a clear record of being firm, fair, and impartial when presiding over these matters. My service has been recognized by the courts on several occasions. I was selected as Outstanding Pro Tem Judge of the Year. I was also given a certificate of appreciation for my service as a Judge Pro Tem in the juvenile courts. Further, I was given the court's highest award, the Amicus Curiae Award, for the attorney who demonstrates the most contribution to the courts. After becoming Dean of Empire College School of Law, I set out to establish a number of free legal clinics to provide access to justice to people who would otherwise not have an opportunity to get access to the courts. First, we opened the Elder Law Clinic. Then I partnered with other organizations to open the Disability Law Clinic. I partnered with the courts to have an evening self-help access center program, and I partnered with the courts to oversee and run the Small Claims Clinic. These clinics serve thousands of people every year free of charge. I grew up in Sonoma County and have been involved in many community organizations, including being a board member for the Crime Victims Advisory Committee, a board member for Legal Aid of Sonoma County, a board member for the Sonoma County Bar Association, and Friends of the Libraries. I appreciate your consideration. Thank you.
Thank you. So those three candidates are for Office 2, and now for Office 3, we will hear first from Mr. Mazzia.
Thank you. Good evening. My name is Chris Mazzia, and I'm a candidate for Sonoma County Superior Court, Office Number 3. I'd like to introduce myself to you on a personal level and on a professional level. Professionally, I have 30 years of experience in the courtroom and as a counselor. I'm senior litigation attorney with Anderson, Ziegler, DeSharoon, Gallagher, and Gray. We have offices in Santa Rosa, Petaluma, Healdsburg, and Oakmont. I have a broad range of civil experience, including environmental cases, employment, business, real property, and many other matters. I have a varied and balanced practice, and I've represented local clients as plaintiffs and defendants in a broad range of cases. On a personal level, I grew up in New York, went to college in Massachusetts, spent a year as a student in Spain, and then worked for a year in Washington, D.C. at the Organization of American States. I came to California in my orange VW Bug with all of my earthly possessions, including my dog, to attend Golden Gate Law School, where I paid my way through school as a temporary typist and as a legal researcher. I met Carol, my wife-to-be, at Golden Gate. We got married and came up here to Santa Rosa, where Carol was born and grew up. That was 27 years ago. We celebrated our 27th wedding anniversary last month, and we're glad to have 3 generations of Santa Rosa High School graduates in the family. We live in the junior college neighborhood. I walked over here tonight, right near Carol's parents, where Carol grew up and where her folks still live. I'm pleased and proud to be a member of our community, having served as chair of the Thursday Night Market, which is now the Santa Rosa Downtown Market, a Project Grad volunteer for many years, and getting back to my professional volunteer work as an executive committee member of the Sonoma County Bar Association, where I've worked on initiatives to improve relations between the bar and the community and the courts. In conclusion, I believe in serving our community and that serving our profession and community as a well-grounded, independent, and impartial judge is the highest form of service that an attorney, especially a courtroom attorney, can aspire to. Thank you.
Thank you. And finally, for the opening statements, Ms. Thistlethwaite.
Good evening. Is this on? Okay.
I think so.
Good evening. My name is Jamie Ellen Thistlethwaite, and I'm running for Office 3 in Sonoma County Superior Court Judge. My roots go back in Sonoma County very far. My grandparents moved here in the 1940s. My grandfather got a job at the Sonoma State Hospital, now called the Sonoma Developmental Center. I moved back to Sonoma County to raise my family after I graduated from the University of California at Santa Barbara. After my 2 children were born, I went to UC Berkeley and graduated with my JD from Bolt Hall. I have been in the courtrooms of Sonoma County since 1980 for over 30 years. Not the boardroom, not the conference room, but the courtroom. We have 8 judges retiring this year. 7 of those judges have criminal law backgrounds. We have 50% of our women judges retiring this year. When I came to Sonoma County, there was not a woman judge on the bench. And I want to see our bench reflect the diversity of our county. I believe that our retiring judges leave a tremendous void of experience and perspective, and I can fill that void. As a judge in Sonoma County, I would stand for justice for all. I would stand for obedience to the law, because a Superior Court judge does not make the law, she follows the law. I would treat everyone who comes before me with dignity and respect. I would protect and defend the Constitution of the United States, a thing I have done for the past 30 years. I believe in the safety and security of our families, and I would make that a top priority. I believe in equality under the law, regardless of race, gender, sexual orientation, religion, or economic status. I am firm, I am fair, I am focused, and I'm a hard worker, and I would bring that to the Sonoma County bench. Thank you.
Thank you. Now some instructions for the audience. If you have questions, this is the time to prepare them. We have members of the league who will bring you cards, so if you have a question, please raise your hand and it will be written on a card, and then the card runners will take them back to our question sorters, also members of the league, who are in back, Muriel Smith and Barbara Kirk. All questions should speak to issues, not personalities. Personal attack questions will not be addressed. The questions asked will be directed to all 5 candidates, and they will be responding in a rotation order. We will rotate between the 2 races, and within those, between the candidates for that particular race. Due to the short time frame for the evening, we may not have time for all of the audience questions. I have several questions that are prepared, and these I will start with while the members of the audience are giving their questions to the card runners and sorters. Each candidate will have 1.5 minutes to respond to each question. And candidates, if you'd like me to repeat the question at any point, just ask. That doesn't go against your time. But don't feel that you have to use all the time if you don't need it. These questions were developed between me and the president of the Sonoma County Bar Association. Our first responder is Ms. Thistlethwaite, sorry. Until they drew lots, she was just a number to me. Now she's someone in a seat. What do you perceive will be your strengths and weaknesses as a new Sonoma County Superior Court judge?
I went to a great law school. It was really, really special. And through that law school, I got the opportunity to work at several different locations. I have been a paralegal in a tax firm of the tax department of a multinational firm. I have been a paralegal in a local civil law firm, Gary Shea and O'Donnell. I also worked as an intern in the public defender's office. I have done TROs, which are civil proceedings, and I have handled many disciplinary proceedings for professionals like doctors and dentists, and expulsion hearings, all civil cases. That being said, my breadth of civil law is somewhat lacking, so I believe that might be a weakness of mine. My strength is that I've been litigating complex criminal cases for almost 30 years, and when I haven't been doing the actual talking, I've been sitting there, watching, listening, learning. Not only from the other attorneys, but also from the judges I've had the privilege to watch these last 30 years. I've learned to withhold judgment until all the facts are in. I've learned that each client of mine has to make a firm decision based on a knowing, intelligent, voluntary understanding of what the circumstances are. I am prepared, and I think my greatest strength will be preparation. My preparation comes from a dedication and a commitment to my cause. Thank you.
Thank you. And next is Mr. Mazzia.
Yes, thank you. I think the strength that I bring to the court is my broad experience on both sides of the table, representing plaintiffs and defendants, landlords and tenants, employers and employees, owners, buyers of businesses, sellers of businesses, all members of this community in all capacities. I've been in the courtroom for 30 years in a broad range of cases that are highly complicated and technical, including environmental cases, site contamination cases. I've handled, as a counselor, land use cases, cases in the coastal zone, employment cases, discrimination cases, business cases, shareholder disputes, a broad range of cases that really make our community go and is the vibrancy of our community. The other strength I have is that as a counselor, I've had to sit on both sides of the table and have difficult conversations with my clients. In the morning, maybe as an employer, afternoon as an employee, to explain the law to them when they're highly emotional and they're set in their ways, to let them know this is how things work in our legal system, this is how it's probably going to work out. I've handled cases that are short and that last well over a month, including hundreds of exhibits, tens of thousands of pages against some of the largest law firms in San Francisco, and large banks, well-financed parties. I've come out with nice results for our local clients. The other strength I have is dedication to the law and application. As part of this candidacy, people have been very generous with their time, and I've sat and listened to many people from all walks of life. Thank you.
Thank you. And next, Mr. Casey.
Thank you. I have 25 years as a career prosecutor of daily courtroom experience, dealing with every case one could imagine could be committed. I've tried dozens and dozens of felony jury trials to a verdict. Before I went to law school and became a lawyer and then a prosecutor, I did some other things in life. As I mentioned in my introductory remarks, I'm a Vietnam combat veteran. I know the dignity of life. I know how fragile life is. I had the last rites of the Roman Catholic Church 3 times when I was in the hospital. I know the human condition. I saw the brightest of the bright of the human condition and the darkest of the dark in Vietnam. As a 19-and-a-half and 20-year-old lieutenant, I was a mother, father, and priest confessor to my infantrymen. A number of them were killed during the time I commanded the platoon. Several literally bleeding out in my arms. So I know people. I respect people. I know we're all different, and we all demand respect and dignity, and I would give that to each individual who appeared in my courtroom. I can hit the ground running. There's no startup time with me. I could preside over a murder case tomorrow morning if I had to. I know criminal law. I speak it fluently. I know the penal code, the evidence code, the health and safety code. I would bring common sense, pragmatism, my experience, and decades of public service to Sonoma County. Thank you very much.
Thank you. And now, Mr. Broderick. Excuse me. Yes, Mr. Broderick.
All right.
Sorry.
Thank you. The strengths that I bring are as follows. I am by far the most experienced candidate in terms of actual experience sitting as a bench officer, as a pro tem judge. As I mentioned in my opening, I presided over thousands of cases. I was a practicing trial attorney for many years before I became dean of the law school, and I tried many jury trials to verdict, so I understand what it means to be the trial attorney. But because of my experience on the bench, I also understand what it means to be a judge. I have had to rule on hundreds of motions, evidentiary motions in the criminal courts. I've had to sentence people and look them in the eye and make those decisions about what was going to be the sentence after the jury returned a verdict. I have also had tremendous experience in my civil practice as a civil trial attorney with many complex cases. And indeed, so I am the person that has that ability across the spectrum of civil law, criminal law, and juvenile law to make an immediate contribution. I have presided over criminal misdemeanor departments where they were so busy I had to call double calendars, where there were so many people waiting in the courtroom, they had to have people step outside. So I have had tremendous experience, and I have the vision to bring more access to justice and to ensure that all people have an opportunity to have access to justice through clinical programs and other programs that I've already designed. Thank you.
Thank you. And finally, Mr. Lamont.
Thank you very much. My strengths are going to be my experience. I've been a civil prosecutor, I've been a criminal prosecutor, I've been a civil defense attorney, and I've been a civil plaintiff's lawyer. I've appeared in every courtroom in Sonoma County. I've handled matters of probate, unlawful detainers, representing landlords and tenants. I've represented businessmen in contract disputes, plaintiffs and defendants. I've appeared on the temporary restraining order calendar on behalf of people seeking restraining orders and those opposing restraining orders. I have even briefly appeared in family law on a family support matter. In the criminal courts, I've appeared in our drug courts, in our mental health courts, in our DUI courts, in our domestic violence courts, in our general felony departments, in our general misdemeanor departments. I have the breadth and experience to hit the ground running, as other candidates say, and I know how to do it. I have been a temporary judge for 17 years. To answer your question, my one negative is that I don't have a lot of family law experience, but I do have both a doctorate in law and a master's in business, and I have a mind that can pick up family law very quickly once I put my mind to it. I ask for your consideration.
Thank you. The next question, some of you have already addressed parts of this, and Mr. Broderick will be answering first. Would you feel more comfortable serving on the civil, criminal, or family law bench, and why?
Well, fortunately, as I've already mentioned, I have extensive experience both on the criminal bench, sitting on the bench, and sitting on the civil bench. I do not have experience in the family law courts, so that would be the area, again, that I would need to get experience to do that. So I would be very comfortable in sitting in any format. I have presided over unlawful detainer trials. I have presided over civil harassment calendars. I have presided over traffic court. I have ruled on thousands of traffic court matters and trials. So there isn't a department that I haven't served in terms of the area of law other than family law. So I would feel very comfortable in any of these areas, and the experience that I would need to get would be in the family law area.
Thank you. Mr. Casey.
Thank you. Well, it would be disingenuous if I did not say that I love criminal law. The basic human condition exists and is played out every day in a criminal courtroom. And as I said earlier, I speak the language fluently. I have been at it as a career prosecutor for 25 years. I am no stranger to civil law. I practiced it for 5 years before I did become a prosecutor. I enjoy criminal law very, very much, and I think I've done a very effective job as a career prosecutor. My reputation as a prosecutor is if somebody deserves a break, invariably they will get it from me, and if somebody deserves the contrary, that happens also. Every case is different. I do not paint with a broad brush. I paint with a very narrow stroke. Each case has to be decided on its own merits, on its own facts, and I would be an asset to the Sonoma County Superior Court, certainly in the criminal department. I would sit wherever I was told to sit, but I would much prefer to serve in the criminal court. Right now, the court is going through a really tremendous transmutation with a profound budget crisis. Our criminal calendars are not getting any smaller, quite the contrary. We're really jammed every day in the felony jury trial departments. We need a manager in there. We need a proven decision maker. We need leadership. We need maturity, and I can bring all of those characteristics to the bench. Thank you.
Thank you. And next, Ms. Thistlethwaite.
Well, I love to learn. I absolutely love to learn, and I can't wait to learn the ins and outs of probate and family law and civil law, but I would be much, much more comfortable sitting in a criminal courtroom. In the U.S., we live by the rule of law, and I became a criminal defense attorney to support that rule of law. We have rights that are guaranteed by our Constitution of the United States, and our system of criminal justice depends on people who understand those rights and are willing to stand up and defend those rights. I've been willing to shoulder that burden for a long time. I'm a mother. I abhor violence, yet I stand beside a person who's accused of hurting someone. I have to put my personal feelings aside. I'm the grandmother of 3 lovely young girls, all under 3, and yet I stand beside a man who's accused of hurting girls, hurting women, but I can put my personal feelings aside. I have been trained to do that from day one. By long-honored tradition, and appropriately so, any new judge is going to be put into a criminal misdemeanor department. I can do that job tomorrow. I can put on the robe and hit the ground running. And I believe when we are dealing with somebody's freedom, even for a short time, certainly if we're dealing with someone's freedom for a long time, possibly the rest of their life, maybe even their life, we need people in our criminal courts that are experienced, that understand the law, and I'm one of those people. Thank you.
Thank you. And I'll bet you can guess, Mr. Mazzia, you're next.
Thank you. My 30 years of courtroom and counseling experiences in civil law in a broad range of cases as plaintiff's attorney and defendant's attorney. What I've learned in those 30 years is how to analyze a problem, including extremely complex problems, problems that involve courses of conduct going 10, 15 years, property cases, environmental cases, how to reach people and reach the core issue quickly and efficiently. I can do that in family law, probate law, criminal law. What I bring is an even-handed, impartial approach to the law, diligence, and commitment to following the law. As part of this candidacy, people have been extremely generous with their time. I've sat down with representatives of the District Attorney's Office, the Public Defender's Office, the Chief Probation Officer, our current sheriff, previous sheriff, and many others to hear their voices as to their concerns for how our courts are being run. I can run an efficient courtroom. I can run a quick courtroom. I can hold people accountable for their conduct, both attorneys and as litigants in the civil field and the criminal field. Thank you.
Thank you. And Mr. Mazzia, you will be the first to answer the next question. What ideas do you have for improving the administration of justice in Sonoma County? And in particular, do you have suggestions for eliminating any scheduling backlog?
May I interrupt?
Yes, I'm sorry, did I
May I
miss you?
answer the last question?
I'm sorry, did I not allow
Yes.
you? I
And I'll be brief.
apologize, Mr.
I'll be brief.
My apologies.
No problems. So, to answer your question, a judge follows the rule of law. And it's the same rule of law that's applied in any courtroom, whether it be civil, criminal, or otherwise. Even administrative judges have to follow the rules. I have been a lawyer for 20 years, a judge pro tem for 17. I know the rule book. It's called the evidence code. It's called the probate code. It's called the civil code. It's called the penal code, the health and safety code. It's all right there in the rule book. A good umpire knows the rules, and I can preside over any of those courtrooms, with the exception of the family law department, because I haven't lots of experience in that department. But as I indicated to you earlier, I have a very facile mind, and I can very easily pick up that area of the law. And I appreciate the opportunity to answer this question.
My apologies. I thought I had it all, my system all worked out. Obviously, I don't. All right. The next question, which I will repeat again, we'll let Mr. Mazzia answer first, which is, what ideas do you have for improving the administration of justice in Sonoma County? And in particular, do you have suggestions for eliminating any scheduling backlog?
It's no secret that the delivery of justice in Sonoma County is under threat. With the budget problems, we have courts being closed, we have increasing number of in-pro pers, we do have a backlog of cases. What I would bring to the bench is adaptability, flexibility, and a great degree of private sector experience. I've been a managing owner of our law firm for many years. I have decades of experience in the private sector. I've worked with budgets. I've worked with doing more with fewer resources. I've worked on personnel issues. I've worked on everything that a manager works with. And that's one of the challenges that's facing our courts today. Adaptability, working as a private sector, working as a team member. The judge just doesn't sit up on the bench and make rulings and everything else works around them. They're part of a team to bring the cases in, to make a reasonable result, to work together. I've done that. In our firm, we have people that have worked with us for 45 years or more. There's something that we're all doing right and lessons that I have learned. Direct calendaring is a very good system that's in effect. Also, alternative systems to the delivery of justice to offer a constellation of services. For example, Veterans Court, Elder Services Court. The court has to be more than a place where you go to either win money, lose money, or get locked up. It's got to be more than that. You can't just bounce people around from one place to another place. That's why some of the innovative ideas that our system has come up with work, and I would forward those, and I have the skills and ability to work with that.
Thank you. And Ms. Thistlethwaite.
Thank you very much. Well, it's no secret that our economy is in the tank. That's not news to anyone on this table or sitting in the audience. And we wonder, what can a Superior Court do? Well, for one thing, we can make sure that our citizens have access to the courts, and that means donating time, perhaps donating part of our salaries. For instance, the homeless court. That's a court where the DA, the public defender, and a Superior Court judge goes out perhaps to like Mary Isaacs in Petaluma. And they have people there who have warrants and they're homeless and they can't be reintegrated into the system because they're afraid. I would be very interested in donating my time to those kind of special courts which would guarantee more access to our courts for people who might not normally come to court. Our Veterans Court hasn't actually started up yet, but there is a plan in place and I have reviewed it, and I think that that's very important. I lost my father in active duty in the service. My children's grandfather is MIA in Korea. I have a stepson in the military, so I have a particular affinity for the Veterans Court, and I would certainly help Judge Medveji access that court. We have to, in these trying economic times, we have to be innovative in our solutions. I'm willing to look at any kind of flexible, innovative plan and participate in that. If that means donation of time and money, I'm willing to do that as well.
Thank you. Mr. Broderick.
Thank you. I'm going to talk about programs that I've already put into place. And these are programs that I was told when I became dean we couldn't get off the ground. And I said, yes, we can. I gave a speech to the Pro Bono Awards Luncheon in 1999, and I talked about my ideas of starting free clinics. And I was told, well, it just wouldn't be able to work because you need money. And I said, no, we'll combine the energy of the law students and the experience of attorneys, and we'll get these clinics going. And these clinics serve tens of thousands of people every year. That is critical because when we serve people outside of the court system, that helps reduce the amount of people that are going into court. What other ideas have I already put into place that what I would bring with me when I go to the bench? Certainly one idea is how do we help people who aren't represented by an attorney? In some areas of the law, particularly in the family law area, 70 to 80% of the people do not have an attorney. That's the mission of the Self-Help Access Center. Because if you can help people before they go to court and help them fill out the proper forms and educate them, that then reduces the impact on the court. What other programs am I already working on? There's already in place, and I've participated in these meetings for an elder law court, which would focus on court issues specifically for senior citizens. Similar to what has already been done with the idea of the homeless court, similar to the idea of the Veterans Court. Education is also a key component. In my experience, everything from working in the small claims clinic to helping people in the disability law clinic or the elder law clinic, the more information you can give to people and the more they can access information, the better you are at reducing the impact on the court system. Thank you.
Thank you. And this time I want to make sure to give Mr. Lamont a chance to answer.
Thank you. This is a topic that is near and dear to my heart. I hold a master's degree in business administration, and I wrote a thesis in 1993 on total quality management in the public sector. It was unheard of. People were saying to me, the government, the public sector, does not run like a business, and look at where we landed ourselves now. One of the things I would like to do is get our cases through the system faster and come to the same justice sooner. We have excellent examples of that in our early case resolution courts, but also as a jurist, a judge can take a look at a case together with a prosecutor and a defense attorney and see what the value of that case is worth and settle it without having to go through a long process. I bring to you an example where I defended someone. It took 8 months to come to the resolution that I had offered to plead my client to on the first day of his arraignment. It took 8 months to get where I knew we were going. And in that 8 months, that file went from the clerk's office to the judge's bench at least 10 times. And each time it went up and down those stairs, it cost money. All that money added up, and now we have a fiscal crisis.
Thank you. Mr. Casey.
Thank you. Well, I'm in the court every day, every working day. I'm the supervising senior prosecutor in my felony jury trial department. I know firsthand the state of affairs in our courthouse today. It's not in good shape. I'm a very, very ardent supporter of outreach type programs to identifiable groups like the veterans, like single mothers, like homeless folks, like people who suffer from AIDS and might have unique legal requirements. I think the wave of right now and the future has to be, of necessity, community support, community volunteerism. Everybody has to get out there and do something. And it starts as simply as court starting on time. I don't know the last time court started on time, which is 8:30. Oftentimes it's 8:45 or 8:50, and you stand there and you burn up 15 or 20 precious minutes. And believe me, every minute in the courtroom is very, very precious. My courtroom would run on time. It would run on time with respect and dignity and efficiency. I'm something of a workaholic. I love to get in there, roll my sleeves up, and get the job done. So there are simple things we can do. Starting on time, volunteer, help. And that is going to be the wave of the future. We have very constricted resources, and they're probably going to get even more constricted. I'm a proven decision maker. I'm a very good manager, and I would get the job done. Thank you.
Thank you. And the next question will go to Mr. Lamont first. What are your personal feelings about the death penalty? How do you think your personal feelings would affect any decisions you might make as a judge?
I will follow the law. Thank you.
Thank you. And next is Mr. Casey.
Thank you. Well, certainly the death penalty is a conundrum that perplexes all of us, along with some other major issues. We have 400 plus individuals on death row right now in San Quentin, and the cost of maintaining them is astronomical. A judge should always follow the law. A judge's personal philosophy should not color what he or she does on the bench. I think ultimately with the death penalty, it's a decision that the community should make. I don't feel that a district attorney should decide whether a case should be prosecuted as a death case or a non-death case. I think it's a basic elementary responsibility of the community to make that call. Put it out into the community and they vote yes or they vote no. I think to take it away from the community is not a good thing. The death penalty right now is in limbo. The costs are astronomical, and it doesn't look like there's any end in sight. But a judge, regardless of his or her personal view, has to follow the law. And again, I would follow the law when it came down to the death penalty. I would like to see perhaps a point in time when we put people in prison for 23 hours a day into a cell rather than executing them. But right now, execution is pretty widespread in the United States. But we have to focus on it here in California, and these death cases are going to be around for a long time. A judge's personal views have no relevancy to a death case, and I will follow the law. Thank you.
Thank you. Mr. Broderick.
It is clear, both under the California Constitution and the rules of judicial conduct, a judge's personal feelings regarding the death penalty are not relevant. As judges, we are duty-bound and sworn to follow the law, and I intend to follow the law of the state of California.
Thank you. Ms. Thistlethwaite.
I will follow the law of the state of California, and the death penalty is the law in the state of California. But I disagree with something that my two learned colleagues say. We have over 700 people on death row, and if we started killing them 5 a month, it would take us 12 years to kill them all. So we have a few more than 400. A judicial candidate, as well as a judge, does not lose her First Amendment right of free speech. And here is the case that shows that, and that is Republican Party of Minnesota petitioners versus White. And I can give you the site if you want it. And here is the canon of judicial ethics, which states judges are entitled to entertain their personal views on political questions. They are not required to surrender their rights or opinions as citizens. And I believe in the First Amendment. And so, although I will follow the law in the state of California, I will tell you that I have a personal opposition to the death penalty. I abhor violence in all forms, as well as I adopt the opinion of Chief Justice of our California Supreme Court, Ronald George, who says that the California death penalty law is dysfunctional. Our Chief Justice says it, and I agree with him. Thank you.
Thank you. Mr. Mazzia?
I will follow the law. I support the law as written, and if a death penalty case is charged, it will be carried forward and prosecuted as provided by law. We've seen horrifying examples in our own county of cases where it's appropriate. Here I stand in stark contrast to my opponent. In seeking a political endorsement, my opponent made a statement publicly reported to the Democratic Central Committee, reading from a report saying that she would do what she could to take the death penalty off the table, including after the jury came back. That was a publicly made statement for dozens of people reading from a report. That report came from an interim committee where her campaign chair sat and participated. So any thought that there was any misreading or misinterpretation of my opponent's stance against the death penalty in terms of taking it off the table, including after the jury comes back, is false. Two members of the interview committee came forward to say that not only did my opponent say that, but she went far beyond that, including the statement that she would look for a way to serve as appellate counsel on appeal for a convicted defendant, which is remarkable, to say the least. Now, once that came out, that public statement, and we called her attention to it, the campaign, the skills that she has learned as an advocate of denial, evasion, excuse, and accusation started going into full play. Well, ladies and gentlemen, that's a stark contrast. I will always follow the law, and I'm not going to put my thumb on the scale of justice one way or the other in any case, no matter how controversial or political.
All right. I believe this is an opportunity to have a 30-second rebuttal for anyone who wishes it.
I do.
So I will
Wow.
give all 5 candidates a chance to rebut if they wish, in reverse order from the last question. Mr. Mazzia?
There's nothing to rebut you.
Okay.
Can I reverse?
Ms. Thistlethwaite?
Wow. If Mr. Mazzia knew anything about capital case legislation, something that I know because I've done 5 capital cases, he would know that the statement attributed to me as being the juror on a death penalty case that would come in under 190.4 subsection E, sign the death warrant, and then quit and become Keenan counsel on appeal is so absurd as to be, could not possibly have come out of my mouth. I bet Mr. Mazzia doesn't even know what Keenan counsel is or what 190.4E is, so what you would have to know to follow the law. I didn't say that. You don't know I said it. You don't even know what hearsay is.
Thank you. I will ask the audience, please, this is not a popularity contest, and I would ask the audience to hold your applause until the end. Let's see. Mr. Broderick, do you wish to make a rebuttal?
I have nothing further to add, thank you.
Okay. Mr. Casey?
No, ma'am, thank you.
Mr. Lamont?
I do have one thing to add, because I deferred my question in the entirety by saying I will follow the law. I think what we need to realize is that judges do not impose the death penalty. Juries do. So when my colleague asked for a community vote, that's what our juries are. The juries are the conscience of our community. Thank you.
Thank you. Our next question, the first response will be from Ms. Thistlethwaite. Do you think a judge should act or behave differently when dealing with an unrepresented litigant as compared to dealing with a lawyer? And do you think any specific local rules should be adopted to address issues related to unrepresented litigants?
In the criminal courts, every once in a while, we have a defendant who decides that they want to represent themselves. And even telling them that if you are acting as your own lawyer, then you have a client for a fool does not help them at all. So what we do in the criminal courts is have them fill out a form, which we call a Ferretta form, and it seeks to explain certain rights, and what it actually does is trying to show them how ridiculous it is to be your own lawyer, because there's so much that can go wrong. But as a judge, I think we do have to treat people who are in pro per a little bit differently because we are interested in due process. We are interested in justice. And if someone is making complete terrible mistakes, I think as a judge we have to step back and give that person at least the opportunity to ask for counsel to help them, advisory counsel, or to rethink their decision to represent themselves.
Thank you. Mr. Mazzia.
A judge should ensure that there's a fair hearing held before him or her. And to that extent, the judge should be sure that a litigant or self-represented litigant has at their disposal tools available to help educate themselves or not to be mystified by some of the strange practices of the court system. Beyond that, though, it's a very sensitive thing in terms of a judge trying someone's case for them and stepping in to be an advocate for that person. That's a very difficult balancing act. Some of the programs that have been talked about in terms of the Self-Help Access Center, volunteer programs, those are critical, those are crucial. Those are appropriate programs to help people. There's internship programs also that should be available. Private law firms could offer attorneys on a pro bono basis to help people that are self-represented. But again, it's a case-by-case basis, and the judge needs to be careful not to step in and be an advocate for someone before them.
Thank you. Mr. Lamont.
Thank you. Justitia is the name of the lady that we see depicted holding the scales of justice. And one of the most important aspects of her is that she is blindfolded. There should not be any special considerations given to people who act on their own behalf, nor there should be any special consideration given to anybody who has a high-priced lawyer. We are all held to the same standards, the same rule of law, the same playbook must be followed by everybody. Due process requires a notice and an opportunity to be heard, and if somebody wants to represent themselves, that is their constitutional right to do so. In the criminal courts, we have public defenders who are able to assist people, and there's discussion in the state legislature to appoint counsel on civil matters as well for unrepresented litigants. There are an overwhelming amount of family law litigants who are self-represented, and although they do not need to be given any special consideration, the judge must take into consideration that they may not know the jargon and the terminology of the courtroom. So everybody has to be treated the same. It's called equal justice under the law, without special privilege for anyone.
Thank you. Mr. Casey.
Thank you. In the same vein, excuse me, that no child should go to bed hungry, no child should want for medical care, nobody in this country should want for legal representation. If someone decides to represent themselves, it is quite frankly a foolish thing to do, because competent legal representation as a foundation requires objectivity. And if one is representing oneself, the human condition does not allow you to be objective. Quite the opposite, you're going to be very subjective, and that's a very, very dangerous thing to do when you're in a courtroom. The FRERETA mentioned by Ms. Thistlethwaite, my mouth is dry, is a document that allows the court to question or voir dire a particular defendant to see if he or she has the educational background to represent himself or herself. And I always kind of cringe in a courtroom, and I see it with some regularity when somebody decides to represent themselves, because I know they're starting down a very dangerous path. And judges will tell them that they can't cut them any slack or give them any special consideration, that they will treat that person like a lawyer. So the person is put on notice that they have to act like a lawyer. But again, it's a very foolish thing to do, and a wise person chooses to have counsel represent him or her. Thank you.
Thank you. Mr. Broderick.
Thank you. This is a very serious question and a very important matter. In the number of times that I have sat on the criminal misdemeanor departments, I've had to rule on FRERETA motions where people have requested to represent themselves. In California, they have a constitutional right to do so, but it is rarely granted because it is a very serious matter when somebody wishes to represent themselves, and as a judge, you have to determine Do they have the background, the training, the education to do so? I am already working on this issue. In fact, there's a program we're establishing at the law school for people who go into the unlawful detainer courts. I have sat on hundreds of occasions over unlawful detainer matters. Inevitably, the landlord has an attorney come to court, and invariably, the tenant does not have an attorney. That is not a fair and balanced level playing field. And so we have a program where we're trying to get law students to work with people and maybe have counsel go to the unlawful detainer calendar with them. We advise people on numerous occasions in a number of these clinics about getting them assistance. I've already referred to the Self-Help Access Center to provide assistance to people. It is a very important matter, and we need to find a method to continue to work hard to get people representation in the civil courts. We do, thank goodness, have a system where people can have an attorney from the public defender's office who work very hard to represent people, even if they can't afford a counsel. We need more programs to work with people in the civil courts.
Thank you. And the next question will be answered first by Mr. Casey. This question comes from our audience. What is your opinion of implementing a night court to better utilize existing county courthouses and facilities? And wouldn't this also accommodate those who work during the day?
What a great question. I have been an advocate literally for years of night court. I think it's a marvelous, marvelous thing to have. It alleviates obviously a great burden on the courts during the daytime. It is a wise use of our very precious resources in this very terrible economy. And I simply do not know why Sonoma County has not chosen, maybe not on a regular basis, but several nights a week, to make use of those courtrooms that sit there dark overnight. Why not use them? It's a wonderful, pragmatic, economical idea. I would love to see it happen, but it hasn't happened. But we sure do need it. We need to try everything within reason to make things work, because things in the future are certainly not going to work like they did in the past. And that certainly applies to the courts. As I mentioned earlier, I'm in court every day, a felony jury trial court. The caseloads are tremendous, absolutely tremendous. I don't know how we can juggle any more oranges than we currently do, but a night court at least 2 or 3 days a week would be a great idea. And I would love to see the powers that be here in the county implement some type of night court. Thank you.
Thank you. Mr. Broderick.
Night courts are not only essential, they're already up and running in some departments. I have served as a judge, a judge pro tem, in small claims court at night, because if you're a working adult and you're the only breadwinner in the family, how can you take time off during the day? So I have been there at night from 5 until 9 o'clock serving as a judge over small claims matters. I have done the same thing with traffic court. We have traffic court in the evening hours for people who simply can't get away to come during the day. We need to implement those ideas in other ways. And again, I've already done this in the law school working with the courts in this wonderful self-help access service program. The courts did a wonderful job in combination with legal aid and to get it started in the mornings. Well, my question was, well, if you're a working adult, you have a couple of children, you have a job, how do you go over and get help during the day? So I said, we're going to start one in the evening time. And indeed, Monday nights, you can come to the law school and get service in the evening. We need to continue in that direction, and we need to be creative and have vision, because it's not always about money. I will tell you the enthusiasm of people who are willing to volunteer their time to be there in the evening, whether it be practicing attorneys in this community. Our attorneys do a wonderful job. Whether it be law students, whether it be other people who are willing to be there, we can do more, we need to do more, and we do need to have night courts.
Thank you. Mr. Lamont.
Thank you. Increasing access to justice for the citizens of Sonoma County is very important. Like Mr. Broderick, I too have sat as a judge pro tem in the night court, handling a small claims calendar. Today I spoke with Mayor Brown in the city of Sonoma. I appeared on his radio show. He asked me, when are we going to reopen the court in the Sonoma Plaza? I said, we used to have a court there, you're right, and we used to have a court in Petaluma and one in Healdsburg as well. Opening those type of facilities would bring access to the courthouse back to the people. The people are the recipients, are the customers of our justice system, and we need to serve our customers better, That's what the total quality management principles of W. Edwards Deming taught me when I wrote my thesis. The customers need to be catered to. So I'm in favor of night court. I sit in night court. I think all of our alternative dispute resolution courts like mental health court, and those of you who are in favor of veterans court should contact your assembly member, because AB 1925 is currently pending important legislation to fund that element of veterans court. And so all of those types of courts are very important to increase access to justice. And I will do everything possible to make my courtroom available to anyone who wants to walk through those doors.
Thank you. Mr. Mazzia.
Yes, thank you. Question was asked earlier about the backlog of the courts. Night court does sound like a tremendous idea. The courts do need to be flexible, both in terms of the programs that they handle, the calendars that they call, how they deliver services, and in scheduling. And it's not just a matter of night, but it's also accommodating people, perhaps with physical or other disabilities or needs, to come at a different time of the day and call their calendar at a different time of day. Yes, it's a tremendous idea. You got to find the money, though. We're in a budget problem. We're closing courts. How can we keep it open at night? That's why I come back to my years of experience in the private sector, working with budgets, working with different groups as an administrator, as a manager, working with the Bar Association, bringing people together, talking about ideas, being adaptable. So yes, that's a great idea. Good thing that we're talking about it, and it's a good idea coming out of this forum. And then you need to bring the energy to bring people together to make it work.
Thank you. Ms. Thistlethwaite.
I think that we are all in agreement that night court would be a good thing, because increased access to the court is something that we all support. I would be very willing to volunteer my time in that regard. It's not just the judge. We have a staff, and the staff probably gets overtime, so it's not as easy as it might seem to say, fine, let's have a night court. But it's something to think about, it's something to plan for, it's something to put up in budget talks, and I certainly would be willing to participate in that. Thank you.
Thank you. Mr. Mazzia will get the first response to the next question. Do you believe that juveniles under the age of 18 should ever be tried in adult court?
Yes, there are certain cases where there's discretion to charge the juvenile as an adult. That does raise problems of due process. But yes, I support that.
Okay, next is Ms. Thistlethwaite.
The law provides for juveniles to be tried as adults. They can either be tried as adults because they've been found unfit for juvenile court, in which there is a hearing process and the district attorneys bring evidence in, as well as their defense counsel. District attorneys bring evidence that they are unfit to be tried as juveniles, and their defense counsel wants them to remain in juvenile court. But there's also direct filings. When the crime is so serious, the juvenile doesn't even go through the juvenile justice process, but there's a direct filing in criminal court. It all depends on the crime. It all depends on the particular juvenile. But in certain cases, I believe it's appropriate.
Thank you. Mr. Broderick.
The law does provide that in certain circumstances, with certain crimes and in certain cases, that juveniles can be tried in adult court. And there is discretion, both with the judge as well as the DA's office. And I do believe there are certain crimes in certain situations where it is appropriate to have a juvenile tried in the adult courts. But my experience has been it's given serious consideration by everybody, and it's not a decision made lightly.
Thank you. Mr. Lamont.
Thank you. The goal of juvenile justice should be rehabilitation, to make people better before they get older. There is a wonderful process at Juvenile Hall called restorative justice, which is a new alternative way to handle cases, which ought to be always considered in juvenile matters. But as Ms. Thistlethwaite indicated, there are two ways that a court can assume jurisdiction: by either a direct filing by the district attorney's office in the adult court, or after a fitness hearing conducted before a judge who hears evidence to make a determination whether or not a juvenile should be tried as an adult. Obviously, certain crimes are so serious and committed in such a serious manner that involve planning and sophistication. They are basically adult crimes being committed by people who are acting as adults. And so there is times when it is appropriate for a juvenile to be tried in the adult courts.
Thank you. Mr. Casey.
Thank you. Well, once upon a time, juveniles used to commit what we call pranks, like something in a Norman Rockwell painting, and that pretty much does not exist anymore. Juveniles commit serious violent felonies today: murder, rape, robbery, arson. A lot of it is gang-related. And we have the means for trying them as an adult. And certainly in the appropriate case, they should be tried as an adult. Because generally speaking, I think that the community is absolutely fed up with juveniles committing murders, rapes, robberies, arson, shootings, gang-related crimes, and being treated in the juvenile system. Juvenile system is diametrically opposed to the adult system. The adult system functions on the principle of punishment, whereas the juvenile system functions on the principle of rehabilitation. The adult court is a public courtroom. People come and go all the time like a train station. The juvenile court is quite the opposite. It's actually locked. The door to the courtroom is locked when the court is in session. And more in Sonoma County, we're seeing juveniles committing these violent, serious felonies, oftentimes gang-related. As one of the speakers tonight indicated, the analysis to make that determination is done very, very methodically and very carefully. But we just live in a day and an age when pranks aren't being committed by juveniles anymore. They're committing serious and violent felonies. Thank you.
Thank you. And the next question will be answered first by Mr. Broderick. How will you hold repeat DUI offenders more accountable?
This is an extremely serious problem in our community, and repeat DUI offenders present not only a risk to themselves, but they're a terrible threat to the safety of all of us and all motorists and all of our loved ones in this community. We have been moving forward in different programs, and in fact here in Sonoma County, I think it's one of the more innovative programs to address this issue. People need to be held accountable for their actions. Actions that not only just affect them, but potentially affect all of us when they're operating an automobile under the influence of alcohol. I have sentenced hundreds and hundreds of people who are both first-time and repeat offenders in the DUI program. The law provides for an escalating system of sentencing, which I support, so that these people realize that it is inappropriate and it won't be tolerated if they continue to put their lives at risk and the lives of the other motorists in these matters. Now, having said that, of course, the cases are different, and you get a report and the information about what is the circumstance that is taking place at that given time. We have a DUI court that we call here in Sonoma County, but these people who drive while under the influence of alcohol, it will not be tolerated, and it needs to be dealt with fairly but firmly.
Thank you. Mr. Lamont.
Repeat DUI offenders are like an unlocked loaded gun on our streets. They have to be dealt with fairly and firmly and quickly. They are a trouble, they are a menace. We basically have a 3 strikes law for DUI offenders. Your first 3 offenses may be considered as misdemeanors, but after that they're considered felonies, and you go to state prison and you're locked up because you're unsafe. We do have DUI court and compliance court here in Sonoma County, where we increase the punishment, as Mr. Broderick said, from minimal punishment to maximum punishment as you go along the continuum. Treatment is always the first important thing to do, because in my practice, I've seen people come into my courtroom, come into my office, I've represented them before, where they come for a first offense DUI and we never see them again. But as they continue to offend and reoffend, it manifests itself as a very serious problem that must be dealt with, and they need treatment and they need to be incarcerated.
Thank you. Let's see, Mr. Casey.
Thank you. Well, child molesters target children, rapists target women, and repeat offenders driving under the influence target everybody in this room. We are all potential victims. And with the myriad of driving under the influence cases I've prosecuted over the years, that thought is first and foremost in my mind. And I don't know how many times I've mentioned that to a sentencing judge. Judge, everybody in this courtroom is a potential victim. Now, a judge is the quintessential community decision maker. And a decision, by its own definition, means that you have to choose between 2 competing sets of dynamics. And again, by definition, you're going to annoy one group and you're going to please another group. But certainly a reasonable judge can make a decision that the majority of the community will agree with. And you're certainly not going to please everyone all the time. But I think a majority of the community wants repeat offenders off of the road. I've gone out to scenes of vehicular manslaughter and seen what's left of a human body after having been hit by someone who's driving under the influence. And these people were 2 and 3 times the legal limit in terms of their blood alcohol at 10 or 11 o'clock in the morning. They had to be prosecuted thoroughly and completely because, as I said in the beginning, everybody in this room is a potential victim. I recently agreed that a former physician should go to prison for 3 years after having given her 3 opportunities at rehabilitation, and she failed. Thank you.
Thank you. Ms. Thistlethwaite.
Thank you very much. I agree with Mr. Casey that repeat DUI offenders target every single member of our community, but every single case has to be handled differently depending on the harm caused, the times, the how many repetitions that the repeat offender has, and I really believe that treatment has to be at a very early level. Because if you have 1 DUI, the chances of having 2 DUIs goes up. And if you have 3 DUIs, then you might very well have a 4th, and that is a felony for which there is the opportunity for prison, but it's not automatic. So I would support treatment at the very first DUI, not imprisonment per se, though there is a mandatory 2-day minimum for every single person who gets that first DUI, but treatment and support maybe 90 AA meetings in 90 days. And if you have a second offense, then be harder and maybe a residential treatment program, because prevention and education is what we need for these people. But if the person continues to reoffend, if they ignore all treatment, all education, if they are ordered to have an interlock ignition device installed on their car and they don't do it, warehousing might be the only alternative at that point, because the public is getting sick of seeing people killed on our roads, not just other people in cars, but pedestrians and bicyclists. We have to share the roads and we have to do it safely.
Thank you. Mr. Mazzia.
Thank you. Excuse me. You know, it's very interesting as I go out and I knock on doors and I meet voters and I talk with different groups. The concern that's raised isn't about gangs, and it's not about drugs, and it's not about the meth labs. It's about traffic enforcement and DUIs. That's a question that I hear again and again and again. And we see examples in our papers where there's concern out there in the community about sentences that are imposed for repeat offenders. Now, I can't comment on any specific case, but I would say for treatment is there for the first-time offender. Treatment is there for a second-time offender, but you know, the point comes with repeat offenders where you look at the circumstances of the situation, and the point comes where you really got to be very firm with people. If it means incarceration, that's what it means, because that's what we're seeing in this community. Thank you.
Thank you. All right, we are wanting to have plenty of time for your 2-minute closing statements, so I now have a real quickie, 30 seconds each. And Ms. Thistlethwaite will be the first to respond. In one sentence, what specifically differentiates you from your opponents?
I have extensive criminal law experience, which will make me ready to sit down in a criminal law courtroom, donning the robe, hitting the ground running, feet to the ground, firm, fair, and focused.
Thank you. Mr. Mazzia.
I have broad experience. I've been an arbitrator. I've been a settlement conference panelist. I've been a judge pro tem. I've made decisions in tough cases. I've handled both sides of cases. I'm free from political influence and the political winds. I'm independent, energetic, and will serve this community in an adaptable way for years to come.
Thank you. Mr. Casey.
I will bring the calluses of life to the bench. Calluses on my hands, my heart, and my mind. Additionally, I've raised 4 children.
Thank you. Mr. Broderick.
What distinguishes me is this isn't something that I can promise you I'll be ready to do tomorrow. I've already done it, and I've already presided over all the departments I've talked about. I have the experience that we need to make an immediate contribution, and I have the vision to continue to come up with innovative and new and creative programs to serve this community and to serve all people, to ensure that the community is protected and that all people have access to justice.
Thank you. And Mr. Lamont.
Thank you. What distinguishes me is that I'm the only candidate here who has both a law degree and a business degree. The only candidate here who has civil, criminal, administrative, and judicial experience, and I bring all those to you to serve Sonoma County.
Thank you. It is now time for the candidates' 2-minute closing statements. These will be given in the order first of Mr. Mazzia.
Thank you. On June 8th, the voters of Sonoma County will choose judges, not advocates and not partisans. We have enough of that in the political arena. What are the qualities that make for a good judge? Balance, openness, listening, understanding, and the skills, energy, and experience to serve the community now and in the future. On the professional side, I have a broad-based experience to serve the community, handling employment, environmental, property, business, and other cases on both sides, as a courtroom attorney and as a counselor. In the future, we have a proud tradition in this county of having civil practitioners being extremely effective, well-rounded judicial officers. At the trial court level, civil lawyers who have become judges have served very well as judges on criminal matters, including, by way of recent example, Judges Wick, Chateau, and Simons. On an administrative level, civil lawyers who have become judges have served very well as administrators and court leaders, including the current presiding judges of the juvenile and family courts, and the current presiding judge and assistant presiding judge, and a number of recent presiding judges. In short, having a well-rounded civil trial and counseling practice is good preparation for serving as a well-rounded, well-grounded judge in all matters, civil, criminal, and administrative. I am so proud to have the endorsement of 3 of the previous 4 presiding judges and many of the sitting judges who will be on the bench next year and not retiring, as well as many community leaders, including our sheriff, Bill Cogbill, our previous sheriff, Mark Eide, community leader Jeannie Schultz, and broad bipartisan support. I'm not in anyone's camp, including Noreen Evans, Efren Carrillo, and scores of community members and leaders. As a candidate, you have to put some humility aside. I do have broad civil courtroom and counseling experience, business experience working with budgets, and experience of doing more with less. I volunteer to serve our courts. I've been an arbitrator, judge pro tem, settlement conference panelist, and I have the energy, independence, and impartiality to serve our community for many years to come. Thank you.
Thank you. Ms. Thistlethwaite.
Thank you very much, and I'd like to thank the League of Women Voters and also the Sonoma County Bar. My candidacy has been endorsed by 19 judicial officers, both seated and retiring. It has also been endorsed by 27 district attorneys, including Greg Jacobs, the former assistant district attorney, and Larry Skofis, who I tried 2 capital cases with. I'm proud of those endorsements. I have the endorsements of Supervisor Zane and Supervisor Brown, as well as Senator Mark Lino. I think that it is important for a judicial officer to have integrity, and I have had the great honor in 2008 as being inducted into a fellow of the American College of Trial Lawyers, which states membership should be limited to those trial lawyers who are unquestionably and eminently qualified. With high ethical and moral standards, professionalism, and excellent character are indispensable attributes of a fellow. What we do is never use a leaked document. What we do when we get a subpoena that we are not supposed to have, we turn it back in. I saw Judge Wick just today take a document that said, this is in my file, and I don't know where it came from, but I'm telling you, I'm not reading it and putting it back. Because as officers of the court, that is what we are bound to do. And that is what I will do. I will have my integrity. I will be honorable. I will support the law. I'm also on the board of directors of the Boys and Girls Club of Central Sonoma County. I sit in the seat that I inherited from Justice Radigan on the First District Appellate Project. I've been on the past board of directors of the California Attorneys for Criminal Justice. As a judge, I will be fair. I will treat everyone with dignity, and I will listen, because sometimes that's all a person needs, is to know that they have been heard, to know that their case has been considered by someone who cares, and that will be me. And I humbly ask for your vote on June 8th. Thank you very much.
Thank you. Next, Mr. Casey.
Thank you. Deeply rooted professional experience, maturity, and unique life experience. I bring all that to the bench. I am a common sense, pragmatic person who loves the courtroom, who is fluent in the language of the courtroom. 25 years as a career prosecutor, and my role model throughout my prosecutorial career has been my dear father, who was a surgeon and an anesthesiologist for 50 years. And his every thought and every move was guided by his Hippocratic oath. And I've never known a more ethical person than my dear father, and I have tried to emulate him in that regard. I can hit the ground running. There's no startup time for me. I know the courtroom inside and out. I know what should go on in a courtroom and what should not go on. My court would run in a timely, respectful fashion with always a bit of humor, because I have a good sense of Irish humor, and I think that's very, very important in this crazy world, is to have some degree of humor. I would be honored by your vote. I am ready to become a judge. This was not a decision I took lightly. My dear bride would like to see me rewire and finish a novel, maybe do some teaching. I'd love to do that. But ever since I've been a lad, I've marched to the sound of the cannon, and I've heard the cannon again this time. I will bring substance, maturity, and experience to the Sonoma County bench, because the bench deserves nothing less, and each and every one of you deserve nothing less. I mentioned earlier that my daughter, my oldest child, is a deputy district attorney here in Northern California. And I'm on the phone with her frequently, discussing some complex evidentiary issue. And then later in the day, I'm talking to my 14-year-old son about getting some wheels for a skateboard. So it really keeps me in balance. And I do like to think that I'm a balanced person, and I would be a very balanced jurist. I think people would enjoy my courtroom. Thank you.
Thank you. Mr. Lamont.
Thank you. The citizens in the community of Sonoma County deserve an independent jurist, and that is what I promise to be as your next Superior Court judge. Judges take an oath of impartiality, not to be beholden to other interests or special interests in the legislature or in the executive branch. Jurists are supposed to be independent. This community needs me on the Superior Court bench. This community includes myself and everybody in this room, my wife and my 5-year-old twins. They are part of the most vulnerable segments of our society, which brings me to the bottom line of my candidacy. In my courtroom, persons who are tried and convicted of child abuse, violent rape, and physical elder abuse will go to jail. This is my simple promise to you, to follow the rule of law and to be a sound jurist that is independent, fair, compassionate, and decisive. And I ask for your vote on June 8th, but more importantly, I ask for your vote the week of May 10th when the absentee ballot comes out, as over half of you will vote by that method instead of on June 8th. So please vote early and vote for John Lamont. I appreciate your vote. I appreciate your time this evening. I want to thank again the League of Women Voters and the Sonoma County Bar Association for hosting this important event. The judicial ballots, unfortunately, are at the bottom of the ballot, and not too many people know what's going on, but I applaud all of you for being here to get information, and I look forward to serving you. Thank you.
Thank you. And Mr. Broderick.
Thank you. I also wish to thank the League of Women Voters and the Sonoma County Bar Association for providing this important forum. I am very proud to be endorsed by Judge Andolini, who is retiring from seat number 2. I am very proud to be endorsed by Judge Bellinger, Judge Bertoli, Judge Boyd, Judge Hardcastle, Judge Tanzel, retired Judges Hanlon, Rosenfield, Sawyer, Commissioner Ornell, retired Commissioners Bonilla and Joy. I am also very proud to have the endorsement of our Sheriff, Bill Cogbill, as well as many other people and community leaders. My service as a Judge Pro Tem and my experience as a trial attorney provide me the experience and the background that is necessary to be an effective trial judge. For 23 years, I've been a successful practicing trial attorney in this community. I've been a successful educator at the law school, and I have had tremendous experience as a judge pro tem on the bench. I am the candidate who has had experience on the bench presiding over civil, criminal, and juvenile cases. And I intend to bring the same energy and enthusiasm to the bench that I have demonstrated in my career as a trial attorney and my tenure as dean. I would greatly appreciate your vote on June 8th. Thank you.
Thank you. I would like to thank all of our candidates for your participation this evening and for your willingness to serve the public as judges of the Superior Court of Sonoma County. Thank you, volunteers from the League of Women Voters, for your assistance in running this forum. Thank you, Sonoma County Bar Association, for co-sponsoring this event. Thank you, Glazier Center. And thank you, members of the audience, for your participation and interest. Remember to vote either by absentee or on June 8th, when the polls will be open from 7 a.m. to 8 p.m. The last day to register to vote in this election is May 24th. You will be able to cast 3 votes for judicial candidates in this county in this election. 1 for office 2 from among the 3 candidates seated on my right, 1 for office 3 for the 2 candidates seated on my left, and 1 for office 1 where the 1 candidate is running unopposed. For more election information, I encourage you to go to the League's site, smartvoter.org. You can also go to lwvsonoma.org for information on the taped reruns of this and our other forums, which will appear on Community Media Center's channels 26 and 30 on the Santa Rosa Comcast system, and also on KRCB. Video replays of our forums are also available on the Press Democrats Watch Sonoma County website. Please join the candidate for Office 1 as well as the candidates for Office 2 and 3 in the lobby at the conclusion of this forum. You will find there copies of the schedules for the taped reruns of the forum, information about the League of Women Voters, and other election information. I want to thank you again for your coming tonight, and good night.